All right, we are live on Facebook. Welcome everybody to my third episode of Conversations with Cody. Today I've got with me Dan Burrows, who's a lawyer and a constitutional expert. And the question we're going to be discussing today, not sure where it's going to go, where it's going to end up, but we're just discussing the constitutionality of a shelter-in-place mandate. Now, we're not talking about the efficacy of the stay-at-home order, whether or not it's effective or whether it was needed or whether it wasn't needed. We're not talking about that. We're simply talking about the constitutionality of the stay-at-home order or the shelter-in-place order today. So Dan, welcome. Thanks for being with me today. Appreciate that.
Yeah, thanks for having me, Cody.
Absolutely. So let's just start with the first question that I have for you. And what powers essentially exist? We can start at the federal level, but what powers exist at the federal level for a shelter-in-place mandate?
Yeah, so realistically, under the current situation, it's basically none at the federal level. What we have to remember is that we have two separate sets of sovereigns, two separate sets of governments that each have their power under our system. So we have a federal government, the national government, that is supreme in those areas in which we have given the federal government power, but then we have states that are supreme in every other area that's left. And so because our Constitution gives certain powers to the federal government, anything that's not explicitly granted is reserved to the states or the people. That's clearly stated in the 10th Amendment. So the federal government does have power to regulate, for example, interstate commerce. So the federal government could, if they believed it was appropriate, limit interstate travel, close down international airports, control or eliminate border crossings, those sorts of things. The federal government could even probably instate checkpoints between states, but they couldn't order individuals residing in a state to just stay home. The states, however, do have that power.
But the feds, I mean, if they're gonna halt interstate travel, would they have to make some type of commerce tie?
Yeah, I mean, really, interstate travel is sort of the fundamental example of interstate commerce, right? You're transiting, between, say, Mesa County and Green River, Utah, or whatever, right? That's interstate travel, and that's clearly within the federal government's authority to control. Now, whether they could just do it on executive fiat, just because the president decides that's what they're going to do, they probably could not. They need some sort of enabling statute from Congress. You could theorize cases in which the state government has completely broken down, in a situation of rebellion or something, and then the federal government essentially steps into the place of what would have been a state government. But obviously that's not the situation that we're dealing with now, and not the situation you would ordinarily, absent very extreme sort of, Cormac McCarthy, the Rhodes scenarios, see in what's simply a disease scenario.
Yeah. So when President Trump has this stay-at-home recommendation, because that's really what it is, a recommendation. It's not really.
Yes, exactly.
Okay, so from the federal government, he doesn't have a lot of, you could say he has power as in he has power of the purse and to persuade people to do this, but really constitutionally, he doesn't have the power to tell people to stay in their home. That resides with the state. So specifically in the state of Colorado, where do they get their jurisdiction essentially to tell us to stay in our homes?
Yeah, so that the states have had traditionally and have as a matter of long-standing legal understanding, and you have to understand this from the perspective of the founders and people who set up the government in Colorado in 1876. Those people understood history, and they understood what powers governments had exercised in history. Especially our founding generation in 1776 was very understanding of those sorts of things. And powers like quarantines, for example, have a long historical pedigree. The word quarantine comes from a French word that essentially has the same root as the number 40, because when it was first instituted was 40 days that you had to stay in once they determined that you had a disease. States have what lawyers, as a term of art, call police powers, but it means far more than simply establishing the police. It essentially gives the state the authority to pass legislation, to pass laws, and to implement laws for the health, safety, and morals of their community, of the community that they have jurisdiction over, of the state of Colorado in our case. Those are the police powers. Now, those are limited, obviously. There's a popular commentator, Kevin Williamson, who likes to call the Bill of Rights the list of things you morons don't get to vote on. And I think that's a pretty good way of putting it, is that even with the police powers, you can't violate things that are specifically said you can't do. And Colorado has its own Bill of Rights, its own rules in the regarding different branches of government, what each branch is empowered to do. But absent something saying you can't do that, there is broad discretion under the law to let those things be dealt with essentially through the political process, rather than having some judge say you can or can't, or if that's why we elect these people. The idea is that we will have engaged citizens who will care about what they're voting for and who they're voting for, and whether they're choosing people who are enabled to exercise these powers wisely. Very few written systems of government can prevent someone who doesn't want to do things wisely from taking a lot of powers that they shouldn't otherwise have, which is why it's important who we vote for.
Yeah. So, let's explore this a little bit, because, obviously the state of Colorado has certain police powers. They have police powers to do certain things, and quarantine is one of them. But what happens when the power to quarantine us runs into one of our federally mandated constitutional rights to peaceably assemble, let's say at church or at a political rally or something like that? Where does the conflict rely, and how do we hold the state of Colorado accountable? Where do these limitations end? Because I can see great abuse from this. You could make a very tenuous argument that, let's say, high fructose corn syrup is limiting our health, is an attack on the health of Coloradans. Therefore, we need to eliminate high fructose corn, make it illegal, things like that. So we can make tenuous arguments based on the health of Colorado, but where do those limitations lie, and how do we deal with that conflict between my federally mandated constitutional rights and police powers in the state of Colorado?
Yeah, so I think there's a couple different issues wrapped up in there, all of them good questions. I think the thing to remember is what you said at the beginning. I'm here to talk about, what is lawful, not necessarily what is good policy or what might be a good idea. So, for example, your high fructose corn syrup example, your question is, what's to stop somebody from doing that? And the answer is voters who won't put up with it. But you certainly don't have a right to eat high fructose corn syrup any more than you have a right to, marijuana is a good example, right? For a long time, nobody in Colorado had the right to smoke marijuana. They could be arrested and put in jail for doing so. And then we changed our minds on that. That's a classic example of the police power in force. Somewhere along the line, the legislature of Colorado decided that marijuana was bad for the health, safety, and morals of our state. And so we removed it. Later on, the citizens changed their mind on that, and via citizen initiative, remove that prohibition. So what's there is active citizenship and voting for people who won't do those things. But stepping back to the church issue, things that are explicitly laid out in the Bill of Rights present pretty difficult issues, particularly in situations like this, like a quarantine situation. Generally, the way the courts view that is that in order to infringe on those rights, so for example, just for easy discussion, First Amendment rights like freedom of religion, freedom of speech, freedom of the press, the government has to have a compelling interest, not just we want to do this. They have to have some strong reason that they absolutely have to be able to do it. And second, they have to do it in the least restrictive means possible to still accomplish that. So there's a good example of a case that was in Kentucky just this last week, where Louisville apparently said they were going to enforce the order, not only to say you couldn't gather in numbers in church, but also you couldn't have so-called drive-up services in the parking lot of the church building. And the federal judge said, look, you can say you're not allowed to gather in, 1,000 people in the church auditorium, but the government interest is to prevent the transmission of the disease, and the least restrictive means of doing that is to prevent people getting in the sanctuary to, breathe on each other or whatever. It's not people sitting out in their car with the service broadcast on the radio, and maybe one guy with gloves and a mask comes to pass you communion or whatever. So that's a good example of where those two things collide, and where it is important to have courts to say, look, you're pushing up on a right that is clearly guaranteed in the Constitution, and in most of these cases is also guaranteed in the state constitution, not just the federal one. But nonetheless, you're pushing up on that right. You have powers, particularly in an emergency situation, to begin to push up on that, but there's a limit, and the limit is you have to do it in the least restrictive means based on the circumstances that you have. And obviously, in a contagion circumstance, there are ways you can still allow people to meet without banning them from sitting in their car in the parking lot.
Yeah. So these tests that you go through in the least restrictive means, they're not in the Constitution. So where do they come from?
Yeah, so that's a good question, and that's a difficult question. They come from case law. So one of the things that conservative isn't really the right word, but I think here, what you have to understand is a conservative judge is not necessarily the same thing as a conservative politician. Judges who are more conservative, they're conservative for the most part because they are very concerned with process and who gets to make these decisions versus what the final outcome is. Politicians, legislators, executives, all those are rightly concerned about outcomes and are properly concerned about outcomes because that's what they're there for in a lot of situations. Judges, though, Colorado doesn't elect their judges. We have retention elections, but nobody ever loses a retention election. At least, as a practical matter, they're appointed. And there's reasons that we appoint them, and good reasons that we appoint them. And federal judges are the same way, and they don't even have retention elections. They're appointed by a president and confirmed by the Senate. But once they're in that seat, the political accountability ends. And so a lot of judges over time have been concerned with the fact that they don't have that political accountability. And so in close questions, they want to defer to the legislature. And so some things are obviously unconstitutional, right? The First Amendment says Congress shall make no law abridging the freedom of speech. So if Congress passed a law that says there is no more freedom of speech, everybody could agree that that's unconstitutional. Beyond that, we get into sort of gradations. And so the court, being concerned that essentially their decisions are final because they're last, right? Nobody gets to overrule the court absent an amendment to the Constitution. The court has said, well, look, we understand that there are certain situations that raise a lot of alarm bells. And so that's how they develop these levels of scrutiny. If you go to law school, you'll learn there's strict scrutiny, which is essentially what we're talking about, which applies to fundamental rights, which for the most part are things that are explicitly stated in the Constitution. Then there's an intermediate scrutiny that applies to things that are a lot of times not explicitly stated, but might be said to be implicit in portions of the Constitution. So a lot of discrimination based on sex, for example, is generally given intermediate scrutiny because it's not explicitly stated, but there is an amendment that says you can't deny equal protection of the laws. And so the court has said, look, in these various categories, if there's something there, we, through our, I don't know if it's wisdom, but their exercise of judgment, whatever it is, have decided that some of these are more likely to be a problem than others. And so the ones that are more likely, we're going to look at more strictly. Yeah. And the ones that aren't, we're simply going to require that the government have some rational basis for acting. So the government can't act completely arbitrarily. We're going to stop that. But if it's not, explicitly stated constitutional right, then because the Constitution gives the elected branches a wide discretion, we're just going to say, as long as you can give us some rational basis, we're not going to get involved.
Yeah. And so
that's why, like going to church, for example, gets a lot higher scrutiny, or frankly, in a lot of recent decisions, buying a gun, because that's clearly stated in the Second Amendment, gets a much higher level of scrutiny than just we're going to shut down restaurants.
Yeah. So they have to have an extremely compelling argument. It has to be short in duration, So that duration is to be set by what, some expert somewhere or a judge or the.
Well, so the duration issue primarily applies to what the emergency is, right? So if your claim is we have a health emergency, there is some consideration of whether the remedial measure is tailored to that emergency. There is some danger that courts will get involved in overruling arguable decisions by the elected branches. And, my personal philosophy is that for the most part, where there's reasonable arguments on both sides, the people who should be making that decision are the people that we actually elected. Because if we don't like it, we can just remove them next election.
Right.
As opposed to somebody who's not elected and has been appointed, especially with the system that we have in Colorado for appointing judges, which doesn't even require some sort of legislative confirmation.
So where do we get into trouble with judicial activism in a shutdown, in a quarantine, something like this?
Yeah, so judicial activism is always a concern.
Mm-hmm.
But I think it's especially a concern here, and even on the right side of the aisle politically, there are a lot of divisions between, folks I talked about who are more conservative in their views of how judges should act, and folks who have assembled themselves under what's commonly referred to as an active liberty banner as to how much involvement judges should have. I think everybody would agree that when we're talking about things that are actually written down in the Constitution, like the First and Second Amendments, judges should be involved in that. Where things break down is when we get to, for example, even the Ninth Amendment, right? Ninth Amendment says simply because we wrote down some rights doesn't mean that there's other rights out there. There aren't other rights out there, right? Mm. What, including famous judges like Justice Scalia have said is, look, yeah, I agree that there's other rights out there, but judges who aren't elected aren't well equipped to determine what those rights are. So there's no manageable standard for me to do that. Other judges have taken a somewhat broader approach and have said, well, look, I'll agree that it's difficult to manage these standards, but if a right has some sort of historical pedigree dating back for a long time that everybody accepts, then we'll accept that even if it's not written down. So a lot of things that fall into that category, regardless of how the court may have reasoned it, whether they put on the 9th Amendment or the 14th Amendment due process or something like that, have been, for example, the right to travel, the right to direct your children's education. There were certain states like in the 1800s that basically tried to outlaw Catholic schools. So people sued on that. Later in like the 1980s, a lot of people wanted to homeschool their kids, and states said they couldn't do that. And the same line of cases resulted in courts saying you have a fundamental right to do that. But in a sort of shutdown situation, I think the longer it goes on, obviously, the more scrutiny that courts are going to give to these as to whether it is narrowly tailored to the particular emergency that the state is facing. But again, that's very dependent on local circumstances. Obviously, I was looking at a newspaper the other day. The number of cases you guys have in Mesa County is much less than we have in Jeffco, in Denver. El Paso County is getting hit really hard. And so what might be an appropriate measure here may not be an appropriate measure in Mesa County. But for the most part, I think judges, except on extreme outside limits, are going to leave those decisions up to the elected officials. And again, I'm not saying that's the best way of doing things, but my job as a lawyer generally is to try and have an idea of how judges view things as opposed to how they should view things.
Yeah. Gotcha. So, there's obviously a big difference between what's constitutional and what's good policy. And the way we control that is by who we elect.
Yes, that's absolutely the case.
Yeah. So, okay, just closing up, we've been going about 20 minutes. But in closing, on Monday, our local health department issued the workforce here in Mesa County to cover their faces. And they've also opened up a line for when people find out that, let's say you're at Home Depot and someone doesn't have their face mask on, you can call the local county. And I know a lot of people are frustrated about this. They think this is far beyond what local officials, especially unelected officials, like a health department director, can do, because that didn't come from the governor, who's elected official. That didn't come from our county commissioners. That came directly from what we would term an unelected bureaucrat. So how does he have the power or authority, if you will, to tell people to wear a mask? And now, he didn't say you have to wear a mask if you're an individual and you're going to Home Depot. He said people who work at Home Depot have to wear a mask while being employed.
Yeah, so he has that power because the Colorado State Legislature gave it to him, essentially. So there is a statute in Colorado that requires every county commission, or the county commissions are allowed to band together. I think that's what they've done, and that's how we have Tri-County Health in the Denver metro area that covers 3 counties. The state legislature required every county commission to create a health board that they can staff and appoint the directors of, however the county thinks is appropriate. But in that statute, once they've created the health board has certain powers. Some of them are clearly laid out. The health board has the power to close schools and public places, to prohibit gatherings of people when necessary to protect health, to establish, maintain, and enforce isolation and quarantine orders. So basically, the legislature, the elected body, has delegated that to an unelected body. Now, issues of delegation have been a controversy in legal circles for hundreds of years. I mean, the first federal delegation case, I think, is 1813, before John Marshall was even Chief Justice. So we're talking about guys who were from the founding generation. That case involved a statute where they enforced, they put a tariff on imports from a country, but the president was allowed to make certain determinations. The tariff wasn't needed and lift the tariff or something along those lines. I don't remember it exactly, but that's the basic outline of it. And the court said that's okay. There's a later case where Chief Justice Marshall, again, a guy in the founding generation, I think he was John Adams, Secretary of State. I mean, somebody can correct me if I'm wrong, but that's what I remember. And then he went on to be Chief Justice. This is a guy who's very familiar with the Constitution, it knows it well, is involved in its implementation from the get-go. And he says, look, you're allowed to delegate some level of power, but it's really difficult to draw the line, for a judge to draw the line as to where you've delegated too much. And basically, since that time, that's been the back and forth in the courts. The Supreme Court has only once ever invalidated a law on those grounds, on delegation grounds, simply because it's super difficult to find a principled way of policing that line, or at least that's what the courts have decided. And they're, again, trying to avoid simply implementing their personal preferences over the elected officials' personal preferences. And because of that, hesitance, it becomes difficult for the courts to enforce it. But it's essentially a delegation. The legislature absolutely has that power, but they've delegated it to a body that's completely unelected.
And for the most part, the Supreme Court has kind of thrown up their hands and said, you guys have given them this power and we're not going to interject, right?
Yeah, I mean, for the most part, the Supreme Court has dealt mostly with federal delegation problems, because state delegation problems are a consideration for state courts. Colorado has some elements of its constitution that could be thought to perhaps require more stringent limits on delegation. For example, Colorado lays out its separation of powers written down a lot more clearly than the federal constitution does. But nonetheless, in the sort of broad scheme of things, the courts have been relatively hands-off on delegation issues, particularly when it comes to police powers. And the public health board is exercising police powers. Now, whether that's a good idea, whether that's a complete abdication of responsibility from elected officials, is outside of whether it is legal, or at least an extremely difficult legal question, which I think that this is. There's not, a clear answer one way or another, except to say that the statute allows it. Whether the statute is a good statute or whether the statute is a lawful statute is a separate question.
Yeah. So to sum up the last 26 minutes, get out and vote. it absolutely matters who we elect to office, because those are the ones that create this type of policy, and those are the ones who actually can have the power by state statute to impose these type of shutdown measures. So it's absolutely important who we elect to office and such.
Yeah, I think that's really important. I think it's good that you're pointing this out to people, particularly in this sort of, this epidemic environment that we have with the disease. I think people are looking a lot more at, are the people that we are electing, the people that we want to wield these broad, awesome powers, and can do so with sober judgment, as opposed to, just running around like a bunch of ninnies or chickens with their heads cut off, freaking out about what's going on, who can really look at what's going on and make wise decisions. I mean, the founders of our country were very clear in a lot of things that they wrote, that the Constitution is pointless if we don't have an engaged citizenry who really cares about who we're electing. So I appreciate people like you who are running for office and that are trying to be engaged and understand these issues and present a candidacy that will make wise decisions for your constituents going forward.
Absolutely. Well, Dan, thanks for joining me today. I know you're probably a busy guy, so I'll let you get back to it. But thanks again, and thanks everybody for joining us on Facebook Live. So guys, have a great day and God bless.
Thanks.
Yep.